Hello, everyone. Again, this is Melinda. We are unable to fix our audio problem. So the only thing that you're going to be able to hear from this room is probably my voice and the couple people that are sitting close to me. So for the panel member or the committee members that are on video, we will do our best to try to include you. I mean, if you want to ask a question, please do. Emily, as you're presenting things, we can hear you, so that's fine. You might have a little trouble hearing us, but we have Colleen here to take notes for the responses if you cannot hear. I'll try to move my computer around. I'm just not sure how good that's going to be because basically we're using my computer as a microphone. But we're going to go ahead and get started. So for all of you, I am Melinda Lee. I am the Deputy Commissioner in charge of the Debt Collection Program. I am not going to have everyone introduce themselves because I'm not sure if you would be able to hear them. However, we do have the majority of the committee is here in person. So very happy for that. So that's one reason why we can move forward, because we at least have the majority of the committee here to get us started. We'll have the commissioner provide some opening remarks, and then we will jump into just a small program update, a very short one, and then we'll start talking about our regulations. So I'll turn it over to the commissioner now. Should be closer.
Thank you. Good morning, everyone. And I deeply apologize on behalf of DFPI for our audio problems, but I am overjoyed that I'm able to participate in this meeting with members of our advisory council in person. Because I've seen them over the past year or so virtually. So this is definitely going to be a very dynamic meeting. And we move forward. We don't let any obstacles stop us. And this is living proof of innovation and creativity. It is a real pleasure for me to be here with you today. But first, I have a few updates from the department, which includes our newly updated strategic plan. And to my right is our Chief Deputy, Casey Musini, who worked very hard in leading us in this strategic plan in which we have labeled our priorities for the given year. So for the 2024-25 fiscal year, DFPI will be focusing on 5 primary goals that will connect and guide our work to deliver on the department's vision and mission for the people of California. These goals include strengthening the financial services ecosystem through oversight and consumer protection, driving operational excellence throughout the department, expanding DFPI's reach and impact, advancing opportunities for Californians to achieve economic security, mobility, and generational wealth, elevating the DFPI's commitment to equity, diversity, inclusion, and accessibility. The DFPI team has also been working hard on various regulation packages. We plan to continue the very productive conversation we started at the last meeting regarding the scope package. We will also discuss the annual report package. The annual report package is a very important topic since the information we received from the annual report is what the assessment is based on. Our legal team will be providing more details on these efforts later in the meeting. We welcome your input on these important topics and rulemaking activities. Thank you for the opportunity to participate today, to learn more about your thoughts, concerns, and how we can all work together in the coming year. And thank you again for your continuing contributions to further the mission of this committee. Your efforts and insights have been invaluable. Now I'd like to turn the meeting over to Deputy Commissioner Melinda Lee for a quick program update before our legal team leads us through the regulatory package decision. Turning it over to you.
Thank you. So I am going to keep my update very quick. Our first item I want to talk about is the criminal background check process. It has begun. It took us a little longer to get the license item on than we thought, but just to let you know, as far as the time for completion, it's 90 days from when that license item went on. So even though we had thought we were going to have it on earlier, as far as the deadline of when everything needs to be completed, it is 90 days from when that license item was put onto the NMLS accounts. We are doing this in a phased process. So phase 1 is only the MU2 filers associated with the MU1s, so not the branch managers. The branch managers will come at a later date. This means that a company's status can change to approved while their branches are still approved conditionally. So just to let you know that. Our time frame is that you guys have 90 days to turn everything in to us, and then we will have hopefully everything in NMLS updated 90 days after that. So that's kind of our time frame of when you can expect completed. Though we have already started, so some of you might have already seen your status change. I do want to put in there that if you have fingerprints already in NMLS system that have not expired, they're good for 3 years, you can request an updated criminal background check. And to make sure, though, if you do that, that you remember to give access to DFPI. So we have found that some people have updated them but did not grant us access. So I just want to make sure to remind you that you have to actually grant us access to see that. All of the criminal background check, the fingerprinting, all of that process is part of NMLS. So if you have any questions on how to grant us access or how to request a new criminal background check or even how to get your fingerprints done, please consult NMLS customer service group, because they are the ones that will be able to help you with instructions. There are online instructions, and the notices we send out include links there. But if you're having any difficulties, please contact them. We completed our first annual report. It was due in March. We are taking a sample of the reports and contacting licensees to review responses. Our hope by doing this is to gather more information so we can provide better instructions next year. So we had some outlying numbers, some things that, we weren't quite sure what they were. So we are contacting some licensees and then randomly checking some other ones. We hope to contact about 10% of the people who submitted an annual report so that we can talk about the numbers, what they are, and make sure we're getting what we expected. And if we aren't, that we provide better instructions next year. So this is, as always, is a work in process as we start implementing each new process in our program. So the last process that we really think for this year is going to be the assessment. So just so you know, that will be happening. That doesn't happen till the end of the year. And then we have had a lot of questions about examinations. We are starting slowly on doing those. So we don't expect to be in full swing for doing examinations until next year, and calendar year, sorry, not fiscal year, but next calendar year. So in 2025. And that's the update on for the program. So Emily, we're going to have to just kind of work through this, but if I can turn it over to you, and if you are having problems hearing and we need to figure out something else, well, I know you can hear me, Emily, but are you going to be able to hear their questions? We'll
Sure.
work it out best we can as we go.
Okay, sounds good, Melinda. Thank you. Hi, everyone.
Now we can't hear you. Oh,
Really? Whoops, can you hear me now?
Some of us can. I can.
Okay, good. And Suzanne just waved, you can. Okay, so it's just Melinda, can your group not hear me?
We can hear you.
Oh, you can now. Okay, great. Okay, so we're going to dive right in where we left off on the scope and records retention program, or regulations package revisions. So please just interrupt me if you want to speak up, but at the end of each section, I'll pause so that Melinda, you can pass it around to your group there and see if anybody has comments. So we are at subdivision K, student loan servicer exemption, and Sergio's pulling up for us. Perfect. Okay, so that's the language we're at. So there are no revisions in the current draft to this section, the student loan servicer exemption. Do any of the committee members have comments about this section, the fact that we didn't revise or change it in any way?
I do not see any hands.
Okay, great. So we can move on to the next section. Private nonprofit post-secondary institution is exempt from debt collection licensure. So we also didn't make any changes to this section. Are there any thoughts from the committee on that?
Still no hands.
Okay. Let me just scroll on through. I've got a lot of notes in my own here. Okay, so then M, we have an exemption for repossession agencies, which also doesn't have any revisions. Does anybody have thoughts?
Still no hands.
Okay. All right, so then we move into section 1850.2, where we have two exemptions, which are, instead of being entity-based exemptions, they're type of debt-based exemptions. So the following types of debt are not consumer debt within the meaning of section 100,002 sub F of the financial code. Residential rental debt, we've added except COVID-19 rental debt as defined in section 1179.02 of this Code of Civil Procedure. So that is a change. Are there thoughts on that?
We're good to move on.
Okay. And then the second type of debt exemption we have is, sorry, it just takes me a moment to scroll through my notes. Homeowners association debts, and that has no changes. Anything from Sacramento?
Nope.
Okay, so then we also have debt arising from a consumer's acquisition of healthcare or medical services where payment is deferred is presumed to be consumer debt within the DCLA. So this is sort of the opposite of an exemption. It's just a clarification. Does anybody have thoughts about medical debt being considered consumer debt explicitly in the regulations?
No.
Okay. The last one is also something we did not change. The failure of a personal check to clear does not create a consumer credit transaction under the DCLA. No thoughts on that, I assume, because there were no changes to it.
Correct.
Okay, so let's get
Oh, wait,
into.
wait,
Oh,
we do have a
oh
thought.
yes, Scott. Hi, Scott. Please go ahead.
Can you hear me or do I need?
can. Yes,
We
I
can hear you.
Very good. So there had been some questions in the comments that were submitted in the last set of proposed regs that I think were followed up on in these proposed regs about whether automobile vehicle leases were consumer credit transactions, since there was some case law, Bescos and the La Chapelle decisions that at least within the context of the FTC holder rule said that vehicle leases are not consumer credit transactions. So I was wondering if there was any further consideration to that issue.
So this revision doesn't make any doesn't call out those particular types of debt explicitly or transactions explicitly, but I'm happy to make note and consider it along with the other comments that, that come from the advisory committee meeting. So I believe you mentioned that those are in the, I see that here. They're in the AFSA comments.
Correct.
Okay, so do you have anything to add to those, or do you want me to just note that you're highlighting that?
I'm highlighting it.
Okay.
If you like the decisions, I can send you those two decisions.
Okay, great. Okay. Thank you for that. Any thoughts from anyone in Sacramento about that?
No.
I have a point.
Yes, Cindy does.
Okay, great.
The California Association of Collectors, they had submitted comments, Emily, with regards to following the consumer credit transactions that are kind of outlined within the credit reporting. Did you pick up on that comment as well? If not, can we add that for consideration?
Mm-hmm. So mirroring the consumer credit transactions in the credit reporting. I think I did see that.
Yeah, that they're not considered consumer debt identified by the credit reporting agencies, traffic fines, parking citations, criminal judgments, fines, restitution orders. I mean, there was a list that was provided in comment.
I did see those. Yeah. So we would, once we settle on final rules and we create our statement of reasons, we'll get into detail. I do want to note, just keeping in mind what constitutes a credit transaction and what are debts that we commonly think about that aren't necessarily credit transactions. So, some of those may or may not be credit transactions, may or may not arise out of a credit transaction, like a fine may or may not. So let me see here. Okay, so any other thoughts on this section or on these comments about mirroring the credit reporting? Okay, so let's move down into document retention, 1850.71. Just see if that's, yep, perfect. Oh, sorry, 1 second. I just lost track of my document. Okay. So this draft does not make any changes to subdivision A. 1, subdivision A, primary subdivision A or subdivision 1. The first change we make here is to subdivision 3. So just to keep us clear on what we're talking about, subdivision 1, subdivision A is what records each licensee shall make and preserve regarding contact with or attempts to contact anyone associated with the debtor account. So the change we made to subdivision 3, the name and contact information of the person the licensee is attempting to contact, we deleted whether the attempt resulted in direct or indirect communication with the debtor. So I'll just pause there if anyone has thoughts about that revision.
Not here.
Okay, great. 5, requiring that if a call is recorded, the recording shall be retained. There's no changes to that. And then subdivision 6, the date, amount, and method of payment made on the debt is added. So any thoughts on either of those? Keeping the recordings and method, amount, and date of payments. I'm hearing none. If we move to subdivision B, subdivision A does not apply to contact made between licensees and debt buyers or creditors. That didn't change. We made some changes to subdivision C, however. So each licensee shall keep and maintain the following information. All employee records we added related to training, performance, and interactions with debtors to sort of narrow that requirement. Any thoughts on that?
I think that there was some concern with, if these are, the actual employee records or just, copies of policies and procedures in order to protect the individual employee files. And I guess the purpose for retaining and or having these subject to examination, review, and or public review. So
Okay,
we have the language that would simply, instead of saying employee records, copies of the licensee's policies, procedures related to employee training, performance, reviews, and inquiries, complaint processing, et cetera, in resolution, but not the actual employee records themselves.
okay. Anyone else have thoughts on that? Comment?
Yeah.
Yes, we do, but I do want to, I'm going to throw something in between.
Okay.
So to clarify, just want to make sure, Cindy, that anything that we have access to for examination purposes
Mhm.
is not part of public records.
Okay.
So if we did have access to it for examination purposes, that would not put it out into the public at all. So exam stuff is confidential.
I would just like to add a counterpoint to that. The information regarding, performance and training of an individual is usually necessary when it comes to so-called bad actors, and events where a company might not want to be held liable for the actions of a bad apple that might spoil the bunch. That is maybe helpful to the company itself, but from the purposes of a consumer advocate where we've sued businesses that have claimed that it is important to look at the past trainings and how the person has been, the individual collector or investigator has been trained to see if they are following policy or not. So if not holding on to that specific employee's training and their individual record, at least a copy of the preceding trainings, a record of the trainings as they've been revised over a matter of time, course of time.
Yeah, typically it would be normal and customary in examinations in other states to maintain your, like a training log, for example. But individual collectors are not licensed by the DFPI. So I think that was, I guess, the question or concern with just the wording of this particular section.
And just so I'm clear, that's Cindy, and was that Desiree? Who else was speaking?
Yes, I'm sorry. I
That's
should
okay.
have said that. Yes,
That's
that was
okay.
Desiree.
Okay, that's what I thought. Thanks. Okay, one moment. Let me just get this. I want to get all this good stuff down. This is why we're here. Okay, so Desiree, I'm hearing your reasoning for wanting this specific, or the reasons that one might want the specific information for each employee. And then I'm hearing a discussion about training logs, and I understand from, I just want to make sure I understand whether that would be like the minimum that you think would be sufficient, Desiree, or if you think that training logs and policies would not quite be good enough. Would you want a log that shows that the employees actually receive trainings on specific days versus just copies of general policies? Or would it be important to know like which employees took which trainings?
Yeah, it's important to know which employees took which trainings, especially as they changed from department to department.
Okay.
Well, in our training log, and I'll just use a real life example, within our office, it's the training topic, and then we have a sign in or a certificate of completion, that we do maintain within our records. So whatever that training is, employee A through, K, they log in, they sign, they get their certificate of completion, but what we actually physically produce is just that copy of that log. Does that make sense?
With the names of the individuals that took that?
Yes.
Yeah, I think we're talking about the same.
Okay, and yeah, Cindy, that's not something you're suggesting we not require.
No.
Okay, so
Personnel records.
okay, yeah. So looking at the three we have listed here, employee records related to training, performance, and interactions with debtors. So I'm hearing some consensus on training. I think performance and interactions with debtors I'd like to hear more about more detail about what kind of records you each think isn't, or you all think is or is not appropriate, if anybody has thoughts.
I don't want to do
Next, ma'am.
I'm not sure that performance is relevant. How well a collector performs or does not perform, as far as dollars collected, et cetera. I'm not sure that performance is necessarily relevant.
And this is Desiree again. I would agree with that. I don't, for the purposes of, I think performance is too subjective. The interactions with the debtor, I think, is more salient. And maintaining the records, as with number 5, if a call was recorded, recording shall be retained. I think that's very helpful in any logs, any call logs or notes that were held on the debtor's accounts. That retention is really what we're looking for. Performance, not as much.
Okay. Okay, that is really helpful. Okay, I just want to get these really clearly noted down. Okay, great. That's great. Let's move down to, the records created pursuant to subdivision A. So now we're back into what needs to be retained. 3, all records of fees, interest, and any charges on debtor accounts accrued since acquisition of the account by the licensee. We made no changes to that section. Anybody have comments about not changing this requirement that this information needs to be retained?
Nothing.
Okay, so number 4, We made one change. Previously, it said records established that the licensee is no longer attempting to collect on accounts that have been settled. We changed that to resolved after comments indicating that resolved is more the language used in the industry. So are there thoughts about that change? Is it sufficient? Would you like additional changes to subdivision 4?
I have a comment.
Yeah.
So the second half of that talks about, and the consumer has been informed of the resolution and that no further collection efforts will be made. That would insinuate that there is a communication, i.e. written communication, that is mailed to the consumer at the time that, you know, you return the account, for example, back to the creditor. And that is not something that is typically done. And, you know, and or retained. Can anybody else speak to their business practices internally? But that is not a requirement. So maybe an or instead of an and, if anything else.
Okay, so establishing that the licensee is no longer attempting to collect on accounts that have been resolved, and that the consumer has been informed of the resolution. So your
My recommendation on that was or that no further collection efforts will be made.
Okay, so I think what I need to understand maybe is with the word resolved. So if debt has been paid or forgiven, or the account is, then would the consumer not be made aware of that? You're describing a situation in which, from the licensee's perspective, the debt has been, or the account has been resolved because it's been returned to the creditor. That doesn't necessarily mean that no further collection efforts would be made, right?
Sorry about that. I can think of a few more situations where you would no longer be collecting on an account, but you would never notify the consumer. For
Okay.
instance, if the account goes out of statute of limitations,
Okay.
you would literally just never collect on it again. You would never mail them a letter. So I think the purpose of the or is there are a lot of situations where you just stop collecting and you'll never send a letter or notify the consumer.
And I might add that 99 and 9/10 of the time, the consumer knows the matter's over because we're not pursuing them, but also it was through communication with them that the matter was resolved, whether it was a disputed matter or they paid the debt or some other settlement was reached. And usually that causes the conclusion. And it wouldn't necessarily require us to send a formal letter out afterward. It would just be a matter of understanding 99% of the time.
Yeah, if the consumer files bankruptcy, for example, that's another one. You know, they're protected by the state. We are not going to send communication.
Required an out of statute account to notify them. There's nothing we can do beyond the scope of anything we can do within the statute or without the statute of limitations. So.
Okay, so I'm hearing that you are seeing a requirement here that you retain a record that you don't create.
We retain records.
It's that you've been informed of the resolution, which would indicate a written communication to the consumer, which is not
a record you make. Yeah.
Or quite a few instances.
Okay.
Which is why we just recommended the word or instead of and.
Yeah.
I can send that language to you separate, Emily, if you'd like.
That's fine. Yeah, I see what you're suggesting. And I appreciate it. I made notes on this. Anybody else? Okay. So let's move to D. The main change, this is each licensee shall retain, sorry, I wouldn't let you get there. Okay. Each licensee shall retain the information in C in a form readily accessible for at least 7 years. We changed it to 3 years. Any thoughts about that?
We're fine with that.
Okay. Who was that? Sorry. Oh, that was you, Melinda, saying
That was
everybody's
me.
fine. Okay. All right. So it's 3 years after any of the following, whichever occurs last. So we've got, I think, 1 through 3 here. For number 1, we again revised to say resolved. So the account has been resolved and the consumer has been informed that they no longer owe the debt and that no further contact or collection attempts will be made by the licensee. Or I'm going to read all 3 just so that we know what the options are before we comment on them. Or the account has been returned to the creditor, whether or not payments have been made, or the account is sold and we changed that, and all collection attempts by the debt collector have ceased. So those are the one of those, the last, whichever is the last of the 3 of those records need to be retained for 3 years following that. So do we have comments? on
My
these
only
readings?
comment was, again, with respect to bond, which is the same language with the and consumer has been informed that they no longer owe the debt.
Mhm.
Again, just switching that to or.
Okay, so since this has alternatives, do either of the other alternatives capture the situation that you're concerned about? So if the accounts return to the creditor, then no consumer would need to be informed, and it could run from, the 3 years could run from that point in 2. So I'm wondering if that captures, so
Well, it's just
either
the
1
and-
or 2.
It's just the and informing, the consumer when that's not necessarily relevant to being resolved. So, even if it's paid or settled, in not every instance are we going to send a paid in full or settled in full letter. So, I understand, the other aspects as far as the or, but I still would have concern with the and consumer has been informed that they no longer owe the debt.
Okay.
So can I ask if it's paid or settled, what record would, if it's settled and the amount is for less than the full amount, if there's no confirmation sent to the debtor, how would the debtor establish that it was settled in full?
Their payment receipt from their
Yeah.
bank.
But what if it was less than the full amount because it was a settlement?
States that it's settled in the account and the notes are taken on that.
So it's a written
It's
record.
reflected in the record.
Internal on the database, yeah.
Yeah, but it's not necessarily mailed to them.
And
So
it's
they don't-
just.
So they would have no way to prove it.
With the consumer at that point, that's the resolution. We'd already be communicating that factor, and I found in some cases, if you send somebody a notice from a collection agency after the debt's resolved, they can kind of sometimes take that as harassment. And so we're kind of in a bad situation there. Whereas when we're communicating with the consumer, we're saying, by accepting this amount, there's a number of different ways that we receive it. One, it's by them stipulating on their payment
Okay,
is one, and the other, but it's always documented in there. And just like when a person pays off the debt, they're no longer going to get any more communication from us because the matter's resolved. It's been remitted to the client and so on. The whole process has been circled completed.
okay, so they'll have written evidence that they were offered that amount as settlement
Well, sure,
and they paid it in performance.
it'll be documented.
Accepting.
We'll
Okay.
also do something where they're offering it because they now know it's concluded because they're the ones resolving it with us. It's through communication with them.
I missed that. How would the consumer know, like I understand how they would maybe know, but how would they have evidence that payment that's less than the amount of the debt settled the debt?
First of all, communication, pardon me, a
Payments.
payment receipt would generally show that. statement.
Oh, okay, I see.
It's something that when you're communicating with a consumer, you're actually coming to the meeting of the minds right there that the debt is being resolved for an X amount. They know it, you know it, or it would have to continue with further communication. By accepting it, receiving it, and creating a receipt of it, we're zeroing out the balance by adjusting off the balance.
So then 1 would be, if we kept and in 1, it would be the payment receipt that they would have. And that would
If the
satisfy.
and- It might be still have to need an or there.
Robert, can you clarify for me, payment receipt, do you actually produce a receipt for the consumer or is it the?
If they add.
Consumer asks for a receipt, which in a settlement, they would always do that.
Not always.
Well, most often they would do that. We just generate a statement that shows the account's closed. It generally is a matter of meeting of minds because you've established a reason. We can't compromise an account for a client and reduce that debt without their approval in the first place. So even in reference to the client relationship, we have to notify them and get, most of the time, to get their approval to settle the account for less than it was assigned for. Generally, the consumer's asking for it already, and then we're agreeing to it, accepting their payment and closing out the account, just like we would any other paid in full account. We then would adjust off the balance and it'd be zero. It would be a zero balance.
I understand. I just want to make sure that I also understand that there are instances where a consumer would not get that receipt unless they asked for it.
Unless they ask.
Well,
for
I
it.
mean, if it's a bank transaction, like a
Yeah.
copy of a canceled check, they would retain in their bank records. If it was a, any kind of other.
Yeah, so
form
they
of
would have to
payment,
get it.
They would have those records, without obtaining that from us. So it would show-
Well, yeah, they would have
to-
record of the, I'm sorry, go ahead. Let me make sure I'm understanding.
But the record of the canceled check, they would have to write down in the memo, then they would have to write in their memo paid in full or some kind of note to say that this was settled,
Not
right?
necessarily, because you would have proof of the payment. I think, the step that we're missing here is that you're never going to find a debt collector or a financial institution that doesn't have record of a settlement offer in their system. So if you have record, because agents aren't allowed to make their own settlement offers. So if you have record of the settlement offer and then you have record of the payment, those two are going to align in the system.
Right.
So that's how we know it was settled for that. And then in most instances where the consumer does not ask for a receipt, they have their proof of payment. It literally only has to be made out to you. It doesn't have to have a special reference.
I'll just note that I've had cases with clients who have had their debt that was settled, sold to a debt buyer. So
And those people.
those do happen. That
Those
does
people
happen.
who settle.
That's an original creditor issue.
Yeah, it's an original
not-
creditor issue, but it's also a case where if you've got an egregious agency that's doing that, let's say I settle an account. Then I call them tomorrow and say, okay, now here's your balance. You guys are gonna get a complaint. You're gonna literally get a complaint about us trying to collect a debt that they already settled because it's already been a meeting of the minds with the consumer. Consumer said, I want to settle this debt for X amount. We accepted it, got approval from our client and closed the account out. Now tomorrow, if I send a letter out or call that person, I'd be in violation. It's over.
Right, I think the issue here is just the language is who is the onus upon right now? Is the onus on the consumer to make the complaint to the DFPI about the actions that were taken? Or is the onus on the business to, make a record as part of their normal course of business and provide that to the consumer?
Right, so
I'm sorry, for me, it's two separate issues, right?
I'm
Because
sorry,
just-
can you tell me who's speaking right now? I want to make sure I get my notes.
Sorry, this is Khalid
Okay.
Bachmiller.
Okay,
Um,
thank you.
Just because you issue someone a receipt doesn't mean you have the proper internal controls to not sell an account that's been settled. Those are two completely separate issues. And I've actually seen instances on the debt collection side as a third-party debt collector where an original creditor has sold an account that was settled and there was a receipt for proof. So for me, those are two separate issues.
Right, but one is defensible and the other one's much harder to prove.
Not necessarily, right?
As-
Because I have the fact that you have made a payment to this creditor. People don't just make large payments.
Well, the problem is, let's say I make a partial payment, right, for the
Right.
debt, it's not complete, and I don't put my memo line that this is paid in full, satisfaction paid in full, right? And it shows that I have a balance still of, maybe there's $1,500 left over, right? That part gets sold to a debt buyer, and then that debt buyer tries to collect on the remaining 1,500. Where's my proof that I settled that? All I have is a check that shows that I paid a portion of my debt. It doesn't say satisfaction paid in full. That's an original code. But it's the consumer's issue because they're now being sued for a balance.
But I think that
They settled.
yeah, I
That's-
think that
yeah.
you are operating from the standpoint that if you said you paid it in full, it would not be investigated. It would be investigated thoroughly.
Problem with that, though, is that the investigation depends on that debt buyer. They can still pursue the lawsuit. Whereas with a court where I have proof of a settlement, it's out of the hands of that plaintiff. You see what I'm saying? It's a
I do.
contract enforcement issue.
I've never been in a court where someone has said they've paid a debt in full and the court didn't believe them.
So one is a contract because there is a contract, the existence of a contract, right? And there's a breach of a contract. The other one where there's an absence of a contract, there's an inability to enforce that contract.
And once again, as a litigator, someone saying I paid a debt, I settled a debt in full is just as much of a contract to me. It's just as much of a, once the money exchanges hands, it's still a contract. It does not have to be written.
Well, and this is going back to the documentation. We're talking about what within the statute or within the regs, what does the licensee have to retain as documentation? So I don't know if we're kind of getting off point a little bit, but
I do feel we are. I think what we're trying to say is there are many instances where there just simply wouldn't be a written receipt. And it doesn't change the person's rights at all, not to me. If you come to me and you say, I have paid this account in full with this settlement, I am going to thoroughly go through those records to prove that you did.
and we have digital records within every database and, you know, in the collection industry that would be able to support this requirement. So without having to send a written correspondence to the consumer saying that they've been informed that a debt has been resolved. Those records are retained. They are part of the other record retention requirements within the database, such as date, time, stamps, et cetera, of the recording of the conversation with the consumer where that settlement offer was made. So I think that, you know, within the scope of this particular wording within this part of the reg, that it is not relevant. There's other areas that will cover what the department's looking for from licenses.
As a litigator myself, you're listening to all the comments, it seems to be an issue with the documentation. And maybe there can be a way of crafting this particular section to stress more on the type of documentation, which would be the type of documentation that would hold up in court if there was ever a dispute or issue. So it's not as much regarding whether there's a letter as opposed to an oral, as whether there is the adequate documentation that a court would recognize.
Like a receipt.
Well, the courts would recognize account note.
Yeah, a receipt.
Would recognize what? I'm sorry.
Count notes.
Or payment history, you know, on. the-
Okay, so for number one, we could say the account has been resolved and this resolution has been has been documented, but not necessarily sent to the consumer. Is that what I'm hearing?
I would actually go with resolved, period, because even if it's not documented, if a consumer comes to you and says, I have paid this account, that should be enough to trigger it.
So the idea here is that after, our examiners are going to come in and they're going to expect to see records being held, being retained for 3 years after a particular thing has happened, a particular event has happened. The debt was sent back to the creditor or the debt was sold. So then 3 years after that, you should still have records. So for number one, what is the examiner going to look at to know that number one has been triggered? How are they going to know it was resolved if it's not somehow documented? Because I'm hearing that both that you do document it and also that we shouldn't specify that it needs to be documented. So I guess what I'm having trouble with is knowing how an examiner who goes in there will know whether you retain documents for 3 years after resolution. How are they going to know there's been a resolution? What are they looking for?
So Emily, in the account notes, well, there's multiple things. Number one, you're gonna see on the consumer's account, a payment history showing the date, time, and method of payment. So there's one. And then further in the account notes, you're going to see account notes on the day, time, and place that payment was accepted or arranged to. And then third, we all within our environment use status codes to indicate what the current status is of that account, paid in full, settled in full, canceled, returned back to client, bankrupt, deceased. All of those account statuses are documented within the system. So whenever you have an examiner that comes in, we explain our status coding system. It is documented on each one of the accounts within the database. It would be very simplistic to have an examiner follow by looking at the account.
Okay, so it's documented, but it's not written up and sent to the consumer. So the account has been resolved.
Not in all instances. And again, we kind of went
So
through
you're
that.
saying in some instances, what?
In the previous section, we outlined some of the instances that would not be relevant to mailing something to a consumer when a debt has been resolved. And the same applies in this section.
But your system, it's going to, we're going to have a payment for, you know, I don't know how much you settle for. Let's say 70% of what was actually owed. And then there's going to be a note somewhere saying that that the account has been, that this constitutes paid in full. So
and then we also document and we send that to our client. If we are working on behalf of the original creditor still, and we are not a debt buyer, then there's further documentation where we remit that payment and report it to the original creditor.
Okay,
there's additional documentation if you are a contingency type collection agency and or not a debt buyer as to the that payment being reported back to the original creditor and the status of that payment.
Okay.
Cindy, would it make a difference on as far as the consumer being informed if so my what I'm hearing, and I correct me if I'm wrong on this, is the consumer is informed by the creditor or the owner of the debt that it's actually settled.
In some
because they're doing this, but not all cases. Okay. Okay, thank you.
What if the debt is still appearing on their Experian or TransUnion account and they want to get that taken off because they paid it or settled it?
So that is a completely different issue because not all debts that are settled come off the credit report right away, right? We have a certain amount of years, depending on the debt, that it's going to remain on the credit report. I know that some debt buyers don't even report to credit. And so that falls back on the original creditor. And in most instances, I only report what has actually happened on the credit report. So it would be reported as closed settled. In the majority of instances, if it's paid in full, then it would be reported as payment, but it would still be there. I am a huge proponent for always reporting accuracy on credit reports. I don't ever recommend that a client delete a trade line. And that's just for records and accuracy.
Okay. I think I've got everybody's thoughts on these three portions in this section. Does anybody have anything else they want to share?
Generally about the regs?
No, I'm sorry, just about that section. We're about to hit our last section and then we can do generally.
Got it. Thanks, Emily.
Yeah. So then the only section we have left is E, which is new. And it just says where a record is subject to both this and regulations, the CCFPL regulations, the longer retention period applies. I think both retention periods are 3 right now, but we've added this section just for clarity. Does anybody have thoughts about this?
Oh, geez.
Think we're good there?
Okay, great. Well, then that's everything. That's the entire scope and records retention revisions package that we have. So before I turn it over to one of my other or I guess back to Melinda for you to pass it off to one of my other legal colleagues, does anybody else have any final thoughts about this regulation, the revisions to this reg package?
Follow-up question. During the last committee meeting, we had the discussion of the attorneys being included in the licensing. I think we had tabled, and somebody was going to go back and do some research on that. I'm just checking to see if there was any updates.
There's no updates on that.
This is Scott. Scott Hyman. My recollection was with respect that the commissioner said she might go and speak with the state bar, but I could be misremembering from the last call.
Yeah, we don't have any.
I had indicated that the state bar, as well as the judicial council of the Supreme Court, needs to be consulted. Primarily because any rules and regulations that affect attorneys in the practice of law, the judicial council through the state bar feels that it is their jurisdiction. And I know that there has been some discussion with the state bar, but there needs to be further discussion, particularly with the judicial council, as it relates to anything that falls in the realm of practice of law. So you can have someone that's an attorney, but not necessarily acting in the practice of law. An attorney could go out and be a professional singer, and that's not in the practice of law. So I think there needs to be further consultation on that matter.
There was a case back in the early 90s under Haight Landau where their attorneys opened a collection agency. Well, now they're acting as a collection agency. That's clear. But when they're practicing law, and that was a distinction that was made, and even after the fact, there was law presented in the state, it had to do with individual attorneys practicing law on behalf of their clients would not be governed. And that was when the Bureau was there as well.
Right. Again, this is Scott Hyman. We look forward to the outcome of those discussions because certainly lawyers who are licensed in California are permitted to practice law in any court, certainly from a litigation standpoint in which they're competent and licensed federal or state, which potentially puts the licensure of attorneys into direct conflict with that, to the extent that there is a sliver of a type of law that lawyers would not be able to appear in court on because they don't hold a license under the DCLA. But I appreciate the commissioner willing to address this issue with with the other agencies and with the judicial council.
And I would say, I think it's a matter that can be easily resolved.
Okay.
And Emily, could I come back to what we were talking about again? This is Scott. Oh my, I just lost what I was looking at. When we were talking about the consumer credit transaction issue, and I had raised the issue of vehicle leases, and I don't specifically recall who raised the other issue about some of the more other types of transactions. I appreciate the regulations looking at specific issues, specific types of transactions that the department is saying are not consumer credit transactions. But I think the point, not of the AFSA comment, but of the other comment in this regard, that the public comment that was filed where there was numbers of things, some of which were fines, but some were home appraisals, funeral services, lawn care, pest control, things like that. I think that what the comments are looking for is more clarity on what the department believes is a consumer credit transaction. Because particularly in my example was leases, but whether it's a short-term residential rent or long-term residential rent, there are things that are financial transactions that are not consumer credit transactions. Which is essentially, I would say, a term of art, where there is not interest charged on that transaction, where there is no APR, that they're not subject to truth in lending or re-levering or the UNRRA Act. And so when we look at the things that the department is carving out already, such as rent or bounced checks, for example, neither one of those transactions, although they're financial transactions, are something that we think of as involving consumer credit, either a product or a loan that is where there is credit extended, right? And so I think that the comment from the Association of Collectors, the public comment where they identified a series of the kinds of transactions and fees, I think what I read out of that is looking for guidance from the department on really sort of the limitations of what is a consumer credit contract in the department's view.
Sure. I appreciate that. And I just want to highlight that the Rosenthal Act uses the same language of consumer credit transaction and has been around a lot longer than the DCLA. So there is case law in this area. So it's not, consumer credit transaction is not a term that, I mean, you know this, but I'll say it anyway. The consumer credit transaction is not a term that we as a department have created and can define on our own entirely. It's a product of another law that has, and now the DCLA as well. So there is already legal precedent on the issue of what is a consumer credit transaction. There's not case law on every single type of consumer transaction out there saying whether or not it's credit, which we would love that too. And we would just, we could take their guidance. So we are somewhat limited as a department in being able to go beyond what courts have already, what is already settled law. So I just want to make that note.
Fair enough.
Yeah. Any other thoughts on this package? Okay, Melinda, if there are no further comments from Sacramento, I'll let you pass it on to whichever attorney is going to cover the next regulation sections.
Yes, so we're going to have just a brief update from Mary Tomei. She will give us what our status is on our other reg package, and then we will move into public comment so that we can try to keep, I know we started late, but we all have busy schedules, so I don't want to run too late today. So we are going to move into public comment after Mary.
Great, thank you, Melinda. Can everyone hear me?
Yes.
Awesome, great. Well, I have a much easier job than Emily did because my rulemaking is comparatively quite short. As you all know, the department issued another proposed rulemaking earlier this year to define net proceeds generated from California by California debtor accounts in the preceding year, as that definition factors heavily into the calculation of the pro rata annual assessment. And secondarily, You also know that an annual report is required, and the statute includes a number of terms that are subject to multiple interpretations. Additionally, that provision of our statute authorizes our commissioner to reasonably require any additional information that she believes should be included in the report about the business and operations conducted by our licensees. So that led to, again, the publication of our proposed rulemaking on those 2 points. It went out for public comment earlier this year. The initial public comment period is always 45 days. That 45-day period has concluded. We received 2 comments to the rulemaking, and we are processing them. They are going to be published on our website, our public website. They should be available for viewing within the next week. And we are reviewing those comments, and we will make a determination whether we feel that modifying the text is necessitated, is something that we should do. And if that is the case, then those modifications, i.e. a notice of modifications and modified text, will be published. And the public, as always, will have the opportunity to submit comments on the proposed modified text during an additional 15-day comment period. So just keep monitoring your inboxes and periodically checking our website, and you should be receiving notice of all that relatively soon. Thank you for your time. That's all I have on it, Melinda, unless anyone has any questions.
I'm not seeing any questions on that then. So if there are any public comments? I'm thinking through. Sorry, I paused there because I was trying to figure out the audio, thinking through. I believe I should be able to raise if you raise your hand, I should be able to unmute you, and we would be able to hear you. And also, you can put anything into the chat and we will get back to you later. And we have instructions. So we don't actually have anyone in the room, but if you are in the room, you could raise your hand. If you're on Zoom, if you use the raise your hand function, and if you've dialed in, then press number 2. I don't see any, so then we will use our last 5 minutes for the committee to bring up any other points they would like to, besides the topic of our scope regulation package. Is there anything else anyone would like to raise or discuss today?
You go first. I was just going to say thank you. I know that there was a lot of technical difficulties at the beginning of this meeting. But I just want to thank everybody at the DFPI for all that you have done to make this meeting go forward. And I truly enjoy working with you.
Thank you.
I'll second that as well. I did have just a question, because at the opening, I believe, Melinda, you had indicated, or someone did, that examinations have started. And I can't recall if it was within this committee or the one prior, but there was, I thought, discussion about sharing the examination criteria with the committee. Or if they were adopting, you know, a checklist that was going out in the examination process or something along those lines, so that the committee could take a peek and provide feedback. No?
Yeah, no, we don't have public, like if you're talking about our work program type things. There is a project now, well, barely started. I mean, I'll tell you, it's going to be 2 years, okay? That we are trying to, when I say we, I'm sorry, I'm speaking as the vice president of NACARA, that we are trying to work on a nationwide set of standards. I mean, obviously every state would have their own state-specific stuff, but that is a project that has been introduced, been voted on to do. And quite honestly, that's as far as it's gotten, is we've voted on to do it, and we have not started doing it yet because it was only voted on a month ago. So that is a long-term goal, is to work with the other states and with the CFPB to have more standardized examination procedures, so you would have a better expectation. But we, as an organization, do not publicize our actual work programs. If you're talking about what we were going to share, and what I think I have shared a little, is how we decide who we're going to examine. That process, how we risk, what we do for our risk indicators, what we look at. We do try to risk scope who we're going to look at. And that's based on report information, looking for size changes in trend changes in numbers. We look at complaints, the severity of the complaints, the number of complaints based on the size of the institution. Those are all things that we look at. And then we will also, we randomly pick a sample every year. And then we work very closely on the multi-state examination group. So we are very involved with that aspect. Because I think I have mentioned before, 65% of our licensees are out of state. So we are working very closely with the other organizations to try to lessen our burden if possible by going in together. And it also helps because then we don't have we don't have to send as many people, we can use each other's resources.
And I would 100% support that. We're licensed in many states. So having a set standard that is adopted by multiple states, then it just becomes, automatic, for the states that you do business in, that these are the deliverables that are going to have to be produced. So that answers my question. Thank you.
You're welcome. So if there are no other comments, the commissioner would like to.
Well, I want to thank everyone again, and I have complete confidence that this program is going to go far and it's going to be strong. I have complete confidence in this council, and I think for me, the real test is how do you meet the challenges? And today, everyone met them beautifully. And I think it was wonderful that we were able to have this in-depth discussion in spite of technology and to give everyone the opportunity to express their views. So wanted to say thank you again.
Thank you all. And if we could put our final slide so that people can see, so our recording will be posted in a few days and available to the public and to anyone else on our website. And our information is on the screen right now. Well, it was there 5 seconds ago. So it is there right now. And if you do have any questions or anything, you can look at, you can email us at dcla.inquiries@dfpi.ca.gov. Thank you all, and we will see you again in a few months. Bye.
Thank you, Melinda. Bye all.
Thank you, everyone.